spiraling rent arrears, anti-social tenants, family needs to move into your property. Understanding how Section 8 operates in practice has never been more important. If you're a private landlord, letting agent, or simply trying to get to grips with how possession works after the abolition of Section 21, understanding the legal requirements for a Section 8 notice has never been more important. Mistakes at this stage can lead to costly delays, additional court proceedings, and, in some cases, your possession claim being struck out altogether. Because every case now faces strict legal scrutiny and potentially a court hearing, getting the paperwork right is no longer optional. One minor error in dates, phrasing, or compliance documentation means the notice fails, forcing the entire process to start over. Over the next few minutes, this guide examines how Section 8 works in practice, the main possession grounds, the procedural mistakes that commonly delay possession claims, the evidence courts expect to see, and the practical steps that can help landlords prepare stronger cases while helping tenants better understand how the possession process works. This video is for educational and informational purposes only. The content discussed does not constitute formal legal or professional advice. Landlord-tenant laws are subject to change. Always seek independent legal advice before taking action regarding a tenancy or serving legal notices. To understand where we are today, we have to look at how we got here. Since the Housing Act 1988, the private rental sector in England relied on Section 21. This allowed landlords to end an assured short-hold tenancy by simply giving 2 months' notice without needing to state any reason at all. It became widely known as a no-fault eviction. However, on May 1, 2026, the Renters' Rights Act officially abolished Section 21. The government's goal was to give tenants greater long-term security and eliminate retaliatory evictions. This historic shift completely changed the rules of the game. Every possession claim in the private rented sector now depends on Section 8 of the Housing Act 1988, as amended by the Renters' Rights Act 2025. For many landlords and letting agents, this represents the biggest change to possession law in decades. Under the previous Section 21 process, possession could be obtained without proving a legal ground. Section 8 is fundamentally different. It now contains 18 statutory grounds for possession, divided between mandatory and discretionary grounds. Each ground has its own legal requirements, notice periods, and evidential threshold. Every possession claim now relies on evidence. The court will expect landlords to demonstrate that they are relying on the correct legal ground, that the correct notice has been served, that the required notice period has been given, and that they have complied with their legal responsibilities throughout the tenancy. Dealing with the changes may seem daunting, but getting it right saves you months of headache and potential financial loss. Although Section 8 has always formed part of the Housing Act 1988, most private landlords previously relied on Section 21 because it allowed possession without proving a legal ground. Since the abolition of Section 21, Section 8 is now the only route to possession in the private rented sector. Instead of asking the court to grant possession without giving a reason, landlords must now prove that one or more statutory grounds for possession apply. Those grounds are set out in Schedule 2 of the Housing Act 1988 and were significantly expanded by the Renters' Rights Act. Some grounds are mandatory, others are discretionary. Understanding the difference is one of the most important parts of preparing a possession claim. Take a look at the official Section 8 notice, Form 3A, and you'll notice that the grounds for possession are divided into 2 distinct categories. Housing practitioners generally view these as 2 very different tactical playbooks, mandatory and discretionary. Think of a mandatory ground as an automatic trigger. Housing specialists explain that if you successfully prove the ground applies, the court must grant a possession order. The judge has absolutely no discretion, no room for negotiation by the tenant, and the judge cannot refuse the possession claim. If the criteria are met, the landlord wins, period. Discretionary grounds, on the other hand, are a negotiation. Here, proving the facts is only half the battle. Firms like Thackeray Williams emphasize that even if you prove the tenant broke a rule, the judge must still decide if an eviction is reasonable. They will weigh your financial loss, the details of your claim against the tenant's personal circumstances. If the judge decides an eviction is disproportionate, your case is thrown out. For example, a landlord relying on discretionary rent arrears or antisocial behavior will need to show previous warnings, attempts to resolve the problem, the impact on neighbors or other residents, and why possession is a proportionate response. Even where the ground is proved and the legal requirements have been met, there are different possession orders the judge may make. For example, on discretionary grounds, the judge may make a suspended possession order, allowing the tenant to remain in the property provided they comply with the terms of the order, such as paying their current rent plus an additional amount towards the arrears. In some cases, the court may also dismiss the claim. Every case is considered on its own facts. Simply proving that a ground applies may not be enough. Practical tip. Mandatory simply means the court must make a possession order if every legal requirement has been met. Think of it like a checklist. Every box must be ticked. Miss just one, whether it's the notice, the paperwork, or the evidence, and even a mandatory ground can fail. Choosing the right ground is just as important as completing the notice correctly, so let's look at that next. Before serving any Section 8 notice, landlords should carefully consider and understand which legal ground or grounds apply. There are 18 grounds. Think of reasons rather than grounds. Different situations require different reasons. As property litigation firms like Goodlord point out, these 18 grounds are a landlord's only legal options. If your situation doesn't fit neatly into one of these official slots, you cannot serve a notice. Full stop. They cover everything from a landlord wanting to move back into the property under Ground 1 to a landlord needing to sell under the brand new Ground 1A. They even cover niche scenarios like redeveloping the building or dealing with the death of a tenant. Serious rent arrears may allow reliance on Ground 8, while persistent rent arrears might also involve Grounds 10 and 11. If a landlord genuinely intends to move into the property themselves, or a close family member intends to occupy it, Ground 1 may be appropriate. Where the property is genuinely being sold, Ground 1A may apply, provided all of the statutory requirements are satisfied. Cases involving anti-social behavior often rely on Ground 14, or, in more serious circumstances, other specific statutory grounds depending on the facts. It is common for landlords to rely on more than one ground where appropriate. That can strengthen a claim if one ground later becomes more difficult to prove. However, every ground relied upon must be supported by evidence. Adding unnecessary grounds without supporting evidence can weaken the overall case. Practical tip. Don't overlook Ground 12. It's the general breach of tenancy ground and can apply where a tenant has broken a tenancy obligation that isn't covered by a more specific ground. If you think serving a Section 8 notice is just a matter of filling out a standard PDF, housing specialists have a blunt warning. Form 3A is a legal minefield. According to compliance checklists from Quartico Housing Law, the absolute number one error landlords make right now is simply using the wrong paperwork. On May 1, 2026, the Renters' Rights Act introduced the brand new Form 3A specifically for the private rented sector. If you accidentally use the old version, or use Form 3, which is now strictly reserved for social housing, your notice is legally void before the court even reads it. The second major error is what solicitors call off-by-one date calculation mistakes. When you serve Form 3A, you must give the tenant a precise statutory notice period, such as a strict 4 weeks for rent arrears under Ground 8, or 4 months if you intend to sell under Ground 1A. When it comes to actually filling out Form 3A, housing specialists look at this form as the foundation of your entire possession claim. If the foundation cracks, the whole case collapses. Now let's address a question that landlords often ask. Do you need to write out the full verbatim legal text of the ground from the Housing Act? The short answer is yes. Landlord compliance guides from the Landlords Guild explicitly state that simply writing Ground 8 or summarizing it in your own words will make the notice legally void. You must head over to the official GOV UK legal wording document, Copy the exact statutory text for your chosen ground word for word and paste it directly into Section 4.2 of the form. But copying and pasting the law is only part of the process. The independent landlord highlights that Section 4.3 requires what the court calls the particulars, or your ground background. This is where you explain exactly how that ground applies to your specific tenant. In a rent arrears case, solicitors at Jonathan Lee LLP advise that you cannot just say, "the tenant owes money." Your background narrative must list the exact amount of arrears, how many months that represents, and a clear breakdown of the dates payments were missed. If you are using Ground 1A because you intend to sell the property, your background must state your clear intent and reference your signed contract with an estate agent. The court may expect evidence demonstrating that intention. This could also include marketing details or other documentation showing that the intention to sell is genuine. Repeat rent arrears grounds require landlords to maintain accurate financial records over time. Trying to recreate those records shortly before a hearing is rarely as persuasive as contemporaneous documentation created during the tenancy itself. The stronger the documentary evidence, the easier it is for the court to understand the landlord's position. This narrative bridges the gap between raw legislation and real-world facts. If it lacks detail, a defense solicitor will have your case thrown out before you can even speak. Finally, look at the signature line. If the property is owned by joint landlords or a married couple, all named landlords must sign and date the form on the exact day it is completed. Treat Form 3A with absolute reverence. Double-check the dates, verify the text, and ensure your notice is watertight before it ever reaches the tenant. Ground 8. Serious rent arrears. The single most critical weapon in a landlord's legal toolkit. Ground 8 is a mandatory ground under the Renters' Rights Act. The financial threshold has changed significantly. It requires a tenant to owe at least 3 months of rent, rather than the old 2-month rule. If a tenant pays off just enough debt the night before court to drop the arrears down, for example, to 2.9 months, Ground 8 instantly collapses. That is why many legal professionals never rely on Ground 8 alone. They will routinely back it up with discretionary grounds, like Ground 10 for general arrears and Ground 11 for persistent late payments. If your mandatory ground fails, your backup discretionary grounds keep your case alive. Practical tip. Do not forget that the law explicitly states that when calculating the 3 months of rent arrears required for Ground 8, the court must completely disregard any amount unpaid due to a universal credit processing delay. That was quite a lot to take in. You don't need to remember everything first time around. Feel free to pause the video or come back to any section as and when you need it. Think of this as a reference guide rather than something you have to absorb in one sitting. Next, let's look at the compliance checklist and the key documents that should be in place before serving a Section 8 notice. Long before serving a Section 8 notice, landlords should make sure their compliance records are complete. Although every case depends on its own facts, judges expect landlords to demonstrate that they have taken their legal responsibilities seriously. That means checking that the property has the necessary safety documentation where required, that tenancy documents have been provided correctly, and that important legal obligations have been met. A typical compliance checklist includes a valid energy performance certificate, a current gas safety record where gas appliances are present, a satisfactory electrical installation condition report, together with evidence that any remedial work has been completed, evidence that the tenancy deposit was protected within an authorized scheme and that the prescribed information was served within the required timescale. New tenancies created on or after the 1st of May 2026. Landlords must provide written information about the key terms of the tenancy before the tenancy is agreed. This can be included within the tenancy agreement or provided separately. Existing tenancies created before the 1st of May 2026, with a written tenancy agreement or other written record of terms, landlords generally do not need to issue the written information. Instead, they were required to provide the official Renters' Rights Act Information Sheet 2026. Older tenancies that were entirely oral, no written record, those landlords must provide the written information about the key terms instead of the information sheet. The written information about the key terms of the tenancy and the transitional provisions under Section 16D are a detailed topic in their own right, so they're covered separately. For now, the important point is to ensure you're complying with the correct requirement based on the date the tenancy began. These documents may not automatically determine whether possession is granted, but missing paperwork can create unnecessary challenges and may raise wider compliance issues during proceedings. Good record keeping isn't simply good administration, it can become valuable evidence in court. Now that we've covered the legal grounds and the importance of compliance, let's move on to another area where possession claims can fail. To be granted a possession order by the courts, a landlord must strictly follow the Court Civil Procedure Rules, CPR. Failing to comply with court procedures, deadlines, or evidence submission rules will result in case being struck out. Practical tip: Civil Procedure Rules. Part 55, the Possession Claims Rule. This is the absolute blueprint for all residential possession proceedings. It dictates the exact legal forms you must file, such as the N5 claim form and N119 particulars of claim, and specifies how the court sets standard hearing dates. Once you're confident the notice is valid, your attention turns to service. After all, a correctly completed notice can still create difficulties if you can't demonstrate that it was properly served. If you cannot legally prove the tenant actually received the notice, your entire eviction case collapses on day one. In a post-Section 21 court system, the judge will not just take your word for it. To prevent tenants from claiming they never received the notice, property litigation solicitors rely on an essential Gov UK court document. Form N215, the official certificate of service. As Clark Wilmot LLP notes, this form was recently updated, meaning you must use the absolute latest version to avoid court delays. Form N215 is a formal statement of truth that tells the civil court exactly which documents you served, who you served them to, and the precise date, time, and method of delivery. Signing this form is a serious legal step. Misstating the facts on an N215 constitutes contempt of court. So, what does best practice look like when serving a Section 8 notice? Housing specialists at the Jonathan Lee Network outline 3 primary court-accepted delivery methods. Personal delivery, slipping the notice directly through the property's letterbox. Solicitors advise having an independent witness accompany you to take a time-stamped photograph of the document entering the box. First-class post, sending the document via standard first-class mail. Crucially, experts warn against using recorded delivery if a tenant might refuse to sign for it. Instead, obtain a free proof of posting receipt from the post office counter, which judges accept as valid proof. The double serve strategy. For maximum safety, many litigation firms recommend using 2 methods simultaneously, such as first-class post combined with a time-stamped email, provided your tenancy agreement explicitly permits electronic service. Furthermore, legal experts at Landlords point out a lethal mistake: forgetting to factor in postage days. If you mail the notice, the law states it isn't legally served the day it leaves your hands. You must add the standard court-mandated days for delivery before your official notice period starts ticking. If your court application is short by even a single day because you miscalculated delivery time, the judge will throw your case out. Practical tip: treat the service of your notice with the same precision as the content inside it. Complete your Form N215 immediately after delivery, attach your postal receipts or witness statements, and secure your proof before the tenant can ever claim they were left in the dark. Simply filing the forms isn't enough. To prevent a defense solicitor from picking your case apart, you must present what property specialists call a court-ready evidence bundle. According to procedural guides from Bundle Creator, a judge expects to see a highly structured, paginated folder that acts as an unarguable roadmap of the dispute. Here is exactly what must be inside that evidence bundle to satisfy a modern county court judge. The expired form, 3A, a copy of the exact Section 8 notice you served, including the full statutory wording, the N215 certificate of service. Backed by tracked postage receipts or witness statements to prove the tenant received the notice on time. The 2-year rent payment history. For rent arrears cases, OTS solicitors warn that you must provide a detailed running schedule mapping out every single payment due and payment made for the past 2 years, or from the date the arrears began to accrue. The pre-action audit trail, copy of text messages, email reminders, and formal letters, proving you tried to resolve the issue or offered a payment plan before resorting to possession proceedings. Compliance guides from Landlord Heaven highlight a critical administrative rule. You must prepare 3 identical copies of this bundle. One for the court file, one to be formally served on the tenant, and one for you to reference on the day of the hearing. The takeaway from the legal sector is clear. A messy case is a losing case. If your bundle is unindexed or missing a single mandatory schedule, your hearing will be adjourned, setting your timeline back by months. If you want your possession order granted, your layout must be professional, your numbers must be flawless, and your evidence must provide a compelling case. Ultimately, a successful Section 8 possession claim does not begin when the notice is served or when court proceedings are issued. It begins from the very start of the tenancy. Good tenancy management starts by setting clear expectations from day one, maintaining accurate records and dealing with issues promptly and professionally. Thank you for watching Tenancy Talk. By combining good tenancy management with careful legal compliance, landlords can establish a robust foundation that supports effective enforcement action if it becomes necessary. The tenancy agreement, the signed contract establishing the relationship, the monthly rent amount, and the tenant's formal obligations.